what courts have to do to make decisions. Okay, now you have to realize that I'm a lawyer in Washington, D.C., New York, and Michigan, and California and Tennessee, which means I appreciate expert evidence law from the sublime to the ridiculous. Every year, when we update the 2-volume set, Cross-Examining Experts in the Behavioral Sciences, I give a state in the United States the award for the worst expert evidence law, and, you know, California wins it every year. It's the hardest bar to pass. It has the worst expert evidence law. It's 100 years behind the time. In addition to that, there's a new book coming out next year, 3-4 volumes, about forensic medicine, forensic psychiatry, and forensic psychology in the courts, okay? And in that book, we talk about Daubert. Judge Stephanie Dimitrovich, the chairperson of the Judges Section for Science and Technology of the American Bar Association, and I wrote this chapter about what Daubert is. And we discuss, since this book is being published for Canadians, U.S. citizens, U.S. lawyers, English, Welsh, Irish, Scots, Australians, New Zealanders, even the Kiwis, we talk about expert evidence from the sublime to the ridiculous. Okay, I want you to know that I lectured about this in Australia, and my motherland is Australia. It's where my mom comes from and all of her people. I'm an Australian citizen, and so I have the right to say the most ridiculous expert evidence law in the world is Australia. That being said, we're going to go through this quickly so you get an idea how the courts are dealing with expert evidence law now. So, even a supremely qualified expert cannot waltz into the courtroom and render opinions unless those opinions are based on some recognized scientific method. Can't waltz into the courtroom. So what do we got here? We've got the Daubert trilogy, right? Daubert, Joyner, Kumho. This sets the stage for rejecting junk science. So, what did Daubert tell us? Now, it's important to remember. It's important to remember in the scheme of things that when the English courts reformed, when the Canadian courts reformed, and when the American courts reformed with respect to their expert evidence law, the Canadians and the English courts were really concerned about travesties of justice where people got put into prison on the wackiest, stupidest stuff. What did the Americans care about? They didn't care about that. They cared about corporations having to pay millions and millions of dollars. So every case that reformed the evidence law in America came from corporations saying, no, we don't want to pay. We didn't like that expert who came and said we did terrible things. Whereas the Canadians and the English courts were looking at bite marks and ear prints and stupid stuff and saying, hey, wait a minute. This is crazy. But what did Daubert do? It made the court the gatekeeper, right? Reasoning, methodology that are offered must be scientifically valid, they said. The trial courts have to focus solely on the principles and methodology. Remember, I'm not going to tell you what to do the past in the United States. I'm going to go through this quickly so you can find yourself and find where you fit. Find where your experts fit, find where your clients fit, find where you as an expert fits. Okay, so evidentiary admissibility shall be based on reliability determined by the degree of scientific validity. Okay, so you can't be drifting too far from shore. It doesn't matter how reliable you are. If you're drifting too far from shore, which is what validity is, right? You won't get it in. It's reliability determined by the degree of scientific validity. So Daubert tells us that scientific methodology means generating hypotheses, testing them to see if they can be falsified. Okay, so when Sean Wygant, the doctoral candidate who's working at psych law, and I look at a problem, we say it's not parental alienation, there's no child abuse, it's not going on here. That's what we start with because of the base rate. That's likely to be what's going on. It's not child abuse. It's not horrible. And then we look at all the evidence, and that that hypothesis is either sustained or it's falsified. Okay, so Daubert said that the scientific knowledge is derived from the bingo, empiricism of the scientific method. Experts must be grounded. Don't need to take notes. You can have this. You can just get it, download this. Experts must be grounded in the methods and procedures of science. Okay, so you can find yourself here. You can find yourself already. Methodology, reliability, procedures, scientific method, reliability, etc. Experts must have a reliable basis in the knowledge and experience of their discipline. Okay, so you put an expert on the stand and you do voir dire, examining them. And you demonstrate they either know the experience and knowledge of their discipline, or they don't. Put them on the stand and grill them. Do you know about this? Do you know about this? Do you tell us about that? Do you know about that? Don't know it? Out of here. Trial courts must be free to apply validity and reliability analyses. So this is Joyner versus General Electric, another corporate case. Toxic PCBs. Experts' conclusions and methodology are not distinct from one another. Your conclusion must be based on good methodology. Experts must have a more rigorous connection between the underlying data and the conclusions than merely their ipsy-dixit. I love that, ipsy-dixit. That means, because I said so. That's what I said to my kids. You got to go to bed now. But Dad, he said, because I said so. But Dad, that's ipsy-dixit. Shut up. The trial courts must have considerable leeway in deciding whether proposed testimony and the proposed expert is reliable. Okay. You know, you can have all kinds of great data, but if you've got an expert that doesn't know what she's talking about, or you can't be trusted, or says one thing one time and another thing another time, the proposed expert is not reliable. The trial court must determine both the validity of the expert's qualifications. Suppose they've never done anything in this field at all, and they're just getting pressed into service. The validity of the fit of their qualifications doesn't fit what we're doing here. And the reliability of the proposed testimony. The experts must demonstrate a valid connection to the pertinent facts as a precondition to admissibility. Okay, you notice that every one of these, all of them, have page listings. You'll find these terms right in the case. Experts, whether basing testimony on professional studies or personal experience is allowed. Professional experience is allowed. Just because you don't have a measure, just because you don't have a test, just because you didn't put calipers on their head to see where the bumps are, doesn't mean you won't pass Daubert. Basing their testimony on professional studies or personal experience, if you apply the same kind of intellectual rigor that would be expected in professional settings, you can get past Daubert. Thus, while scientists must ground his opinion in the reasoning and methodology of science, a professional from a less scientific discipline may still qualify. Okay, but doctor, this is a soft science. Every time they say that, I think of like erectile dysfunction, you know. Psychology is just a soft science. But professional studies and personal experience in that field are valid and can be reliable. So how do courts make their decision? How do courts make their decision? Remember that when all of this reviewing of expert testimony was going on in Daubert, Kumo, Joyner, the court fell back on. This is when the Supreme Court in the United States was in fact supreme. It is no longer. Fell back on the rules of evidence and all of the advisory committees to the rule of evidence descriptions over time. You remember, the federal rules of evidence in the United States have an advisory committee that works very hard to make sure that the rules are properly interpreted, and 702, the expert evidence rule, can be draconian, and the court fell back on the rule in getting rid of Fry. Remember, Fry is 100 years out of date. So California, expert evidence law in California that's, general acceptance based is 100 years out of date. It's insulting to science and methodology because it just isn't how science is done. There are many things that are not generally accepted that are perfectly valid and reliable. Okay, so what does the court have to do? First, the very first thing the court has to do is they have to make a determination of helpfulness. Now, I did a case in Canada recently, and I was basically brought in to borrow the justice's watch to tell him what time it was. And I was just going to explain that everything that had been done in the case had been done pretty well, and they'd come up with decent conclusions, and I was being brought in to sort of gild the lily. Okay, well, I certainly had things to offer, and I could certainly give expert testimony that would pass Mohan, the Canadian test, that was opposed to the alienating parents testimony, but the judge did the very first thing that you do in Mohan, and that is, do I need this? Do I need it? And the answer was, well, Dr. Lorandos, I said, Judge, I said, Justice so-and-so, I don't want to borrow your watch to tell you what time it is, but I'm really relying on the things that you've said in this case before. And he goes, well, Dr. Lorandos is eminently qualified, but I don't think I need this. He was right. He didn't need it. So the very first thing the court has to determine is if scientific, technical, or other specialized knowledge will assist the trier of fact, that's the judge or the jury, to understand the evidence or determine a fact and issue. Remember, we're following the rule. The first word is if. Remember, all of you philosophy students know if-then argument. If-then rhetorical processes. If we need it, well, how do you determine if you need it? Do an offer of proof. Here's why you need it, Judge. Conduct a 104 analysis. There are many examples of cases where one of the complete whack jobs of forensic psychology or psychiatry is in there to talk about sexual abuse allegation or what she or he seems to think. And the courts and the lawyers say, no, wait, we want to have a 104 hearing. A 104 hearing is to find out if there's sufficiency and validity and reliability in what they want to say. Ask for a 104 hearing. This is a federal rule of evidence. There are corresponding rules in Canada, England, Wales, Australia. Conduct a hearing. Conduct a Rule 403 analysis. Okay, what does that mean? Is it more prejudicial than probative? Is it more, does the prejudice that it would cause outweigh the probity? So this is all part of if we need it. Okay. Well, if no, you don't need it, you're done. Move on to another witness. If it's yes, we do need it, you go to the next part. Second, you make a determination of expert qualifications, because after all, this is about expert testimony. So the first thing you decide that you need it. The next thing you decide is, well, okay, is this stuffed shirt in front of me an expert? A witness. Qualified as an expert by knowledge, skill, experience, training, or education. There you go, boys and girls. Are you qualified by knowledge, skill? Mr. Jansen's certainly qualified by skill, isn't he? You didn't expect that, did you? Training or education may testify thereto in the form of an opinion. Why is this important? Because nobody gets to give an opinion in a court of law under evidence rules unless they're an expert. Oh, Your Honor, it's my opinion that my ex-husband is a pile of crap. Sorry, you're not allowed to offer opinions. Just give me the facts. But experts offer opinions. So the second decisional issue is that you've got an expert in front of you. Well, how do you do that? You find out with a voir dire, an examination, what's their knowledge, what's their skill, what's their experience, what's their training, what's their education. I had one of the essential detractors on the stand in a case. She said that she had survey the literature of parental alienation. She and a nurse colleague wrote an article about how it's pedophilia and Richard Gardner's a douchebag and all that kind of stuff. Oh, darn it, I promised I wouldn't use that word anymore. God. Okay. And so I queried her under voir dire, and I said, okay, well, you say that parental alienation is just a scheme by mean, nasty, terrible men to take children away from protective women. Okay, is that what it is? Got it. All right, fine. Tell me about the books written by women who are victims of parental alienation. Oh, you can't think of any? Well, I got one here. Do you know this one? No, you don't know this one. What about this one? You don't know this one? Oh, well, how about this one? You know about this one? No. Okay, what about this one? You know about this one? Oh, you don't know about this one? Okay, what about this one? Don't know about that one? Okay. So you say that you know, you have an education in this and that you've surveyed the field. Okay, can you name any case from anywhere where the court had talked about parental alienation as being probative, material probative, relevant, and admissible? No, but we have a lot of cases. Just a second, I'm asking you about cases where it was material, probative, relevant, and admissible. Well, what we've collected cases where, excuse me, my question was, can you tell me any case where a court or a appellate court has said that this parental alienation stuff is probative, material, probative, relevant, and thereby admissible? Well, no, I can't. Well, I got 500 of them right here. You can't tell me even one of them, and I'm sheeping through the cases. Not one. So in voir dire, you find out if this person is actually an expert. Now, there are many circumstances where the court will admit them anyway, right? That's a Daubert challenge. That's appealable. That is against the expert evidence law of the state or the province on its face. If they're not, you're done. If they are, keep going. Okay, the third is a reliability test. Make a determination of reliability. Can we rely on what this person, we know we need it. We know this person's an expert, not done yet. We're going to do a reliability analysis in 3 steps, and we're following the rule. If, here we go again, philosophy fans, if then, okay? If, 1, the testimony is based on sufficient facts or data. Okay. Do you know about this? Do you know about that? Have you heard about this? Can you tell us about that? You don't know the facts or data? Well, how do we determine if, and this is a quantitative analysis. Sufficiency of facts or data is a quantitative analysis. You don't know enough facts? We question your reliability in this case. So, well, how do you determine if they know enough facts? Require an offer of proof. Make them prove it. Do an analysis of whether they really know what they're talking about. Find out if it's more prejudicial than probative. If they don't know enough facts, they haven't got enough relevant facts under their belt, give her a chance to learn them. Give her a chance. You know, it doesn't mean we throw her out. There may be some more facts that just came up that she would need to know. So if no, you move on to other witnesses. If she can't be rehabilitated to learn more facts, then you move on to other witnesses. You're done with your Daubert analysis. She's gone. But if yes, and you've determined that we have enough time to let her get up to speed, keep going. So if yes, the sufficiency determination has been made, we can continue. What's next in this 3-part reliability analysis? A qualitative part, remember? Quantitative, qualitative. If, 2, the testimony is the product of reliable principles and methods. That's a qualitative analysis. What's the quality of the methodology that this expert has used? Every one of these points that I'm making here is a place for you to stumble or to make the proposed witness stumble, because we're trying to keep junk science out of the court. How do you determine this? How do you do this qualitative analysis? Require an offer of proof. Do a 104 hearing. Find out if it's more prejudicial than probative. If it's not, you're done. But if they make it past this part of the test, keep going. 3, This is a fit analysis. You can remember this. Does it fit the facts of the circumstances? Does it fit? Is it right? Does it fit? Okay, you'll remember that one. So a fit analysis, and the witness has applied the principles and methods reliably to the case. Does their method, does their procedure, do their qualifications, do they fit what we're trying to do here? Because they could be a wonderful expert, very valid and reliable, good, wonderful methods, but they're an expert in dog shows. That's not what we're doing here. How do you find out? Offer proof, 104 hearing, 403 analysis. If no, they're done. If yes, they're admissible. The expert's opinion must have a reliable basis in the knowledge and experience of their discipline. I love voir dire. I love voir dire because in this one example, which we talk about in the upcoming book, this particular witness didn't know anything. Couldn't name a case, couldn't name a book, couldn't name a treatise. None. And she published before that she had surveyed the field. Okay. So compared to a lay witness, experts purport to offer testimony that's scientific. So let's test them. Knowledge connotes, and these are really important little phrases by little tidbits. But, Your Honor, knowledge connotes more than subjective belief or unsupported speculation. That's what the detractors are doing. Unsupported speculation and subjective belief. I just spent a bit of time with people who have been victimized by detractors. And they base everything that they're doing on subjective belief and unsupported speculation. Out of here. That phrase alone is gold for you. Okay, is this expert qualified? Do the qualifications of this expert fit the facts of the case? What was the method's scientific validity? What is the scientific validity of the methodology the expert used? What's the reliability? Remember, validity, reliability. Validity, I've been writing about expert evidence law for 20 years for Thomson Reuters West. This is the era of reliability testing. Reliability testing is what Mohan is about. Reliability testing is what Dasreef is about. Reliability testing is about what the expert evidence rules in England, Canada, United States, the entire British Empire, and even the Kiwis. Unfortunately, my mates in Australia just can't get there. Apologies to David Curl. So what's the scientific validity of the underlying data that the expert bases their opinion on? What is the scientific reliability that she's basing her opinion on? What's the expert, is their reliance on the data reasonable? Well, I've got 600 scientific treatises that say there's something to this parental alienation, but I got the Washington Post article written by some stringer and for the magazine that says it's a bunch of bunk. Well, so what's the reliability of how they're basing their opinion, how they're balancing these things? These are all analytically distinct concepts. Okay. If you say we're not negligent, who am I to question it? In order to qualify as scientific knowledge, an inference or assertion must be derived by the scientific method proposed testimony must. That's a magic word. Must. Not should, not oughta, not gee, it would be nice. Must. Must be supported by appropriate validation, good grounds based on what is known. Not what's your subjective belief, not what you're pulling out of your... Thank you. So, in order to aid the gatekeeper, a good voir dire examines whether the expert's opinion is and knowledge is based on the knowledge of their discipline. Okay, so in voir dire, which is extremely helpful to determine what's going on, there's a whole bunch of stuff we want to know. Is their experience on point? What's their employment history? They are licensed. Have they done any publications, any academic appointments, advanced degrees, professional-related community activities, association memberships, board certification, autonomy, ability to speak freely, practice in this particular field, percentage of income that's done from expert work, all the kinds of things that lawyers are going to use to examine proposed expert witnesses in the voir dire. Remember, voir dire is your opportunity to either get it in or get it out. Okay, so after 20 years of publishing, cross-examining experts in the behavioral sciences for Thomson Reuters, 6 years ago, the principal attorney editor, Thomson Reuters, and I started a new project 6 years ago called The Litigator's Handbook of Forensic Medicine, Psychiatry, and Psychology. The point of this book was we're going to update and we're going to give the litigator stuff that she can immediately use to go to court. So every chapter deals with subject matter. What is this and why should it be in court? The next section is, how do you get it in when it's good? How do you get it in? The next section is, how do you keep it out when it's bad? The next section is, the ugly. What are the travesties of justice? If you had any idea how many people have been put into prison on false coerced confessions, on stupid bullet lead analysis, on insane sexual abuse that happened analyses, on ridiculous ear prints and fingerprints, and do any of you remember when the Spanish commuter train was blown up in Spain, and they got an American attorney from Washington State and said its fingerprints match. The FBI crime lab, I love cross-examining people from the FBI crime lab. That is just a joy to my heart. So the FBI crime lab goes to the federal district judge and says, it's a slam dunk, Your Honor. We got the guy based on the fingerprint analysis. Okay, well, it turns out that domain irrelevant information factored into that decision. How? Well, it turned out that Attorney Mayfield had married an Egyptian college professor's daughter. And because he had a good heart and felt things were moving, his life was moving in this direction, he converted to Islam. And they had a wonderful family life in Washington State. That's a long freaking way from Spain. But they got his fingerprint, and the examiners and the people who are making the decision heard that he was a Muslim and said to the judge, it's a slam dunk. So that domain irrelevant information skewed their decision, and it turned out that it wasn't a guy at all. And the FBI apologized to him personally and paid him zillions of pennies for what they did to him. So we want to know whether the expert's technique or theory can be tested. That is, whether the expert theory can be challenged in some objective sense, or whether it is instead simply a subjective, conclusory approach that cannot be reasonably assessed for reliability. So these are the kinds of questions that the Federal Rules Advisory Committee asks. What's the known or potential error rate? Now, if you don't have a known or potential error rate on, you think that this is parental alienation, does that disqualify you? No. No, you're not sticking a probe up some car's exhaust and finding out that Volkswagen has been lying to everybody for a decade, right? You're not doing that. You're not doing gas chromatography. Oh boy, I can't even. I'm getting tired. So testability is a key question. Test your hypotheses. Start with, it ain't happening. And see if the data causes you to falsify this. Because remember, the base rate suggests it isn't happening. People get divorced all the time. People have conflicts over their kids all the time without sabotaging the relationship with the other parent, without becoming narcissistic little cruds, right? So the base rate of the phenomenon is low, thanks be to God. I'm sure she's in heaven thinking about us at this moment. So test it. And if you falsify your hypotheses, then you're going to be in a much better place to give accurate testimony than if you look at your data and you try to find in your data what you're looking for. There's a statement that's attributed to Goethe. We look for what we know. We find what we look for. There's a new paper that's out about when women allege abuse, they lose custody. And several people are looking hard at that. I was asked to write a rebuttal or to write a comment about that for a professional journal, which I did, coming out next year. But when you look at this particular study, you see, whoa, what's going on here? Hey, what? So no falsifiability, just driving toward a conclusion and finding things that confirm what it is that you thought anyway. You set up what you call a paradigm case, and then you go searching for it. That's not how science is done. Professor Harmon would flunk you out of a research class. You don't do science that way. That's not how you do it. So by falsifiability, we're doing proof by disproof. Okay. Proof by disproof is exceedingly important. So you develop alternative hypotheses and see if they're sustained or disproven by the evidence that you're getting and you're looking at. So all scientific research ultimately depends on proof by disproof. So has your theory or methodology been peer-reviewed? What does this mean? Has your theory or methodology been published in a reputable journal with at least a board of 3 editors have examined all articles for publication? I just did a article that's coming out in the American Journal of Family Law about parental alienation and family bridges and all that kind of stuff. And their editorial board went over it and over it and over it. I did one for the AFCC, their Family Court Review. Their editorial board went over it and over it. Professor Harmon and I just sweated out review after review after review, remember that? And just got an important article on parental alienation and domestic violence, direct and indirect methods of alienation and violence published. But that's what we do as scientists. We accept the responsibility to have them write back to us and say, hey, you said this, does your data support that? Or when you say that, or where did this come from? And I'm getting these emails from Jennifer, hey, you need to substantiate and I'm writing back, okay, I'm on it. That's good. That's quality control in science. So your methodology, peer review is one valuable way of dealing with it. So if your technique or your theory or your research has been peer reviewed, you can say it passes a general acceptance criteria in Daubert. Done. Got it in. Okay. Is parental alienation, are parental alienating behaviors violence? Yes, they are. Nobody on the planet says this better than the Canadians. They say this is domestic violence. And Mandy Matheson from Australia, Jennifer Harmon from Colorado have written a terrific chapter for the upcoming book on all these wacky, terrible, horrible, interpersonally violent behaviors that alienators do. And they've tied every example to peer-reviewed literature. And Dr. Burnett and I send it back to them and back to them and back to them and back to them, as scientists do. And they wrote again and again, and more substantiation, more substantiation. It is a kick-ass chapter. That's how science is supposed to work. Okay. Even if the scientific evidence is not generally accepted, in the scientific community, the trilogy still allows for the admission of evidence, provided its reliability has other independent support. Okay, so is parental alienation junk science? Well, I don't know. Look at the Vanderbilt PASG library with 1,000 articles that are relevant to the topic. Gee, okay. So, be able to cite the literature to back up your conclusions. Here's my co-author Terry Campbell put this in our book on cross-examining experts. Question, have you seen any literature that is definite about it? I can't cite anything right now. Oh, okay, he qualifies. He's got a license. Wow. Remember, sometimes you're going to get a judge who's just too dense to follow their own law and will admit stuff anyway, and that's terrific appellate. Those are terrific appellate grounds. Okay, error rate. Is there an error rate in your measure? Can you specify what that is? In the behavioral sciences, questions addressing error rate are most applicable to classification endeavors and prediction attempts. Testing. Because what are we doing with testing? We're comparing the subject to an array of subjects. You know, I just had all kinds of blood tests done, right? And they were comparing them to guys my age, like 95-year-old guys. They're comparing to guys my age to find out, how do I compare? When we take psychological tests, we're being compared to a vast population that's taken this test before. So there are comparisons. There are error rates. There's static in there. There are errors of measurement. There are errors of interpretation. All kinds of errors. But most times, they're acceptable ranges of error. When classifying or predicting some event, decision-making can result in any one of four possible outcomes. A true positive. We said it's happening and it's happening. Right? Or we determined that something condition exists and we're determined to be correct. Or true negative. We've determined that something doesn't exist and we've been determined to be correct. Or false positive. We've determined that something exists but we're wrong. False negative. We've determined that it ain't happening and we're wrong. Okay. Standards and controls. Well, the American Psychological Association, when they enforce their ethics, which they usually don't, we're looking at standards of control, appropriate methods of assessment. We're looking at assessment instruments. We're looking at ethical guidelines with respect to the use of assessment instruments. What about clinical experience? Well, yippee. We wrote a big chapter in cross-examining experts on people coming in and relying on their clinical experience. Well, Your Honor, I've been a psychologist for 26 years, and in my practice, Okay, let me ask you something. Have you been videotaped in your practice and had people watch you and see if you know what the heck you're doing? Well, no, I'm a senior psychologist. Okay, well, have you published in any peer-reviewed journal and had your opinions analyzed for whether or not you're on target or not? Well, no, I'm well respected in my community. Remember that thing about can't waltz into court with unsupported stuff? Too often, your clinical experience is going to cause you to be disqualified. Why? Because clinical judgment refers to the subjective impressions and opinions of mental health professionals developed over years. In my clinical opinion, based on my clinical judgment, always give way to examples of clinical judgment. And the cross-examiner asks, do opinions based on clinical judgment actually assist the trier of fact in decision-making? Look at Robin Dawes. Now, there was a huge debate about this in science, and it's pretty clear when you use Paul Meehl and data-based, evidence-based decision-making processes and compare them to the subjective beliefs of clinicians, you find out that clinicians get it wrong all the time. So, subjective clinical experience is usually the best way to get yourself thrown out. Clinical judgment and inter-rater reliability. Well, we know what inter-rater reliability is. I mean, we were just talking about what's the inter-rater reliability on this study that we both just looked at. There isn't any. There's no published data. We don't know what they were doing. We don't know if Lefty was rating things the way Righty was rating things. We don't know what the inter-rater reliability is. What's inter-rater reliability? We get Bill and Susan and Dave and Pete and Carol, and they all basically say, yeah, within a range, yeah, that's right. But if you got Bill and Susan, Dave and Harry and Carol and everybody saying, well, I don't know, well, maybe this and maybe that, you don't have any inter-rater reliability, right? It's sort of like test-retest reliability. You know, you give an instrument one time and they're freaking psychotic. Give them the same test the next time and they're Santa Claus. Well, maybe that's the same thing. So inter-rater reliability refers to agreement. So, because of the idiosyncratic and subjective nature of clinical judgment, the levels of inter-rater reliability are quite poor for two or more professionals interviewing the same patient. Inter-rater reliability. In Sterling versus Vesical, in order to prevent deception or mistake and allow the possibility of effective response, there must be a demonstrable, objective procedure for the reaching the opinion and qualified persons who can either duplicate the result or criticize the means by which it was achieved. Okay, so another example from a paper that Professor Harmon and I are looking at is there is no way to test these hypotheses about inter-rater reliability or how they did it or what they did because they won't share the data. Well, if they won't, let's suppose you disagree with Professor Harmon, right? And you don't like what she wrote in such a story. Professor Matheson, you don't like what she wrote in a particular thing. You call them up and you say, hey, I don't like what you did. I want to see your data. They're not going to say go pound wood. They're going to find out if you're legitimate, if it's a legitimate inquiry, and if it is, they're going to send you their data. Why? Because that's how science is done. But when you ask the folks from DV Leap or Leadership Council or the Center for Judicial Excellence what they're relying on and what their data is, click. What? That's not science. That's advocacy and, in some senses, stupidity. So when you look at Inree Paoli Railroad Yard, Merrill Dow, Daubert versus Merrill Dow, United States versus Downing, inter-rater reliability is deeply entrenched in reliability testing. Research demonstrates that inter-rater reliability can be poor. 4 graduate students in psychology interviewed each of 4 patients. After interviewing these patients, the graduate students dictated a report identifying the patient's problem areas. The level of agreement regarding the identified problems ranged from only 40% to 50%. Well, like flipping a coin. We were talking about conditional probability the other day, or just this morning, and during a break, I offered an example. Sexual abuse happened here based on this evidence. Or how likely is sexual abuse based on this evidence? Or sexual abuse is X likely based on Y evidence. That's 3 different ways to talk about Bayes' theorem. Sexual abuse is X likely based on Y evidence. Everybody starts backwards. We've got this evidence. We know Bill dictum. And we can tell Bill dictum because we've got this, this anal winking, the anal orifice winking, right? Well, look back at 20 years of data from hospitals and sexual abuse medical exams and the extent to which anal winking happens, which the CPS people and the child protection people say, well, since they never lie, this has got to be an example of, but it's not a rare phenomenon. But sexual abuse is a very rare phenomenon, okay? So, no, wait a minute, I said that backwards. Anal winking is a very rare phenomenon. It's hardly ever seen, but it does occasionally happen. So if you've got a rare phenomenon and a rare phenomenon, the likelihood that you got the guy is very low. So what's sexual abuse is X likely by Y evidence. Well, if you look at how often sexual abuse happens, how often it happens in the general population, you see that the likelihood is very, 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 very low. And so then if you have another phenomenon, the likelihood of which is very, very, very low, what's the likelihood that this thing happened? Very, very low. So low that when you do the math, you find out that for a variety of symptoms and signs, it's less than flipping a coin in the courtroom. So what do? I take $50 and go in the courtroom and I'm cross-examining experts. Say, think you can beat me? Think you can beat me? Can you beat me? You can't even get to 50%. Are you going to base this guy's life on it? Juries love that because it pisses them off that these stuffed shirts come in and say these things that have, when you really unpack them, have extremely low likelihoods. Okay, so how am I doing on time? 12 more minutes, okay. So inter-rater reliability is important. We're going to talk more about that later. Validity, it's a touchstone of evidentiary admissibility. So, what are some important types of validity? Internal validity, the process by which we infer that a relationship between two variables exists or is causal. Construct validity, the extent to which the test or experiment is measuring what we think that it's measuring, the construct. External validity, the ability to generalize to particular person settings or things from the data. Statistical conclusion validity, proper statistical methods lead to testing the significance of a reasonable relationship between factor A and B. There's all different kinds of validity. There's different kinds of reliability. But this is the era of reliability testing, which is based on validity. Okay, base rate. I love this one. Okay. Let's talk about base rate for a second. It happened? Nothing happened. Let's talk about Dad screwed 12-year-old Susie. Now, if Dad screws 12-year-old Susie, I vote for castration. But that's just me. But let's find out. It happened. Dad screwed 12-year-old Susie. Okay? You want to know about that. He didn't. Dad didn't screw 12-year-old Susie. Okay. See this line? If we just look at the base rate, how many 12-year-old Susies get screwed by their dads? Well, thanks be to God, I hope she's listening. This line goes way, way over here because the base rate of the phenomena 12-year-old Susies get screwed by their dads is astronomically low. Don't freaking forget that. Okay, well, we see, let's substitute behavior with symptom or sign. Susie's got tearing of the vaginal orifice. Well, okay, you know, if you're a CPS worker and you don't know what you're doing, your hair is going to get on fire. I have a 12-year-old girl that's got minor tearing in the vaginal orifice. Well, what does that mean? How many 12-year-old girls have tearing in the vaginal orifice? Oh my God! How many do? A lot. A lot. So, where does this line go? This line goes because tearing, no tearing. Tearing, no. He did it, tearing. What's the likelihood of sex abuse given the evidence? Well, he screwed her, he didn't screw her. She's got a tear, she doesn't got a tear. All right, the base rate of 12-year-old girls getting screwed, this line goes way over. And what's the likelihood, and how ubiquitous is tearing? This line goes way up there. So we're left with a little teeny weeny box way up in the corner. We started out going, oh my God, we're going to err on the side of caution, and we're going to put Dad in a chastity belt and lock him in solitary until we get to the bottom of this. Wait a minute. This is a fundamental base rate error. The likelihood that you got him is astronomically low because the phenomenon is astronomically low in the base rate. And this symptom that you see, this tearing of the vaginal orifice, happens so often in situations that as a distinguishing sign, its value is just about nil. So what do we really have here? We have a likelihood that is maybe 0.2, 0.15, so low that you know you could flip the coin and flip the coin and flip the coin and be better and 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 better than the prediction based on that crap all year long. These are the kinds of things that need to be considered when you're trying to pass a Daubert test. And here are some examples of texts that may be of some value to you. This one comes out next year. We got 44 authors from 5 different countries on this one. And hopefully some of this stuff will be of value to you in helping you understand how to pass Daubert. Certainly we discuss this in the upcoming new book on parental alienation. This is a flagrant plug for these books. We talk about a variety of things. See that? See where it says parental alienating behaviors? What do these bastards do? What do they do? What do they actually do? Where's the compendium? Well, we know what their strategies are, but what do they do? And how does that tie to the peer-reviewed literature? Well, Harmon knows. Matheson knows. When you read their chapter, you'll know. So, you'll hear tomorrow about what is it, how many of these cases actually are admissible. You'll read, if you want to, about the importance of voir dire and how to do this. You'll get all of the cases put in an appendix. You'll have all the tools you need to deal with this. Thank you very much.